await now is the ruling, and the ruling has to do with a matter that on the surface appears very simple, but had to take several hours of debates and arguments in court by the two respondents, lead counsel for the two respondents, Mr. Justin Amenuvo and Mr. Akoto Ampao, debating with Mr. Chatru Chikata as to why they would not present witnesses to be cross-examined. The court had to adjourn till this morning to come up with its ruling. Whichever way it goes, it is still unclear if immediately, for example, if the court decides that the respondents must present their witnesses to be cross-examined. What is not clear is if that cross-examination will proceed immediately. Should the court then dismiss the application for cross-examination of the witnesses of the respondents? Again, what is unclear is the next step that will be taken. All these decisions remain in the hands of the judges, and whatever decision is taken, we will ensure that we break it down once again to your understanding. But again, a quick background to why we are here in the first place. President Mahama, after the 2020 elections and its declaration thereof, has petitioned the Supreme Court to annul the results as were declared, because there were some anomalies, and according to the petition, of course, Mr. Frank Davis is one of the lead counsels for the second respondent. He has arrived and is going through the protocols, will make his way to the courtroom. Again, taking you back to the story. So, former President Mahama, okay, and then we have Mr. John Boydu. Mr. John Boydu is the General Secretary of the New Patriotic Party. The leading parties in this case are all interested in very much in this matter, and so all the leading figures and leading party officials have been here since day one. The chairman of the NDC, Mr. Ampofo, as well as the chairman of the MPP, Freddie Blay, have all been here from day one. And talking about leading figures in the party, there we have Mr. Johnson Esedun Ketia, the General Secretary of the MPP. Of course, he was the first person to witness for the petitioner as well. He has also been here from day one. On the first day Mr. Johnson Esedun Ketia sat in the witness box, he hardly answered any question, because then the issue had to then do with some other matters before eventually the following day his cross-examination began. So he's one of those who has been cross-examined by lawyers for the first and second respondents. Of course, we know that the petitioner has presented three witnesses already. Mr. Johnson Esedun Ketia, the General Secretary of the NDC, his cross-examination was immediately followed by the cross-examination of Dr. Michael Pesa-White. Dr. Pesa-White was one of those who represented the petitioner in the National Collation Room, what is popularly known as a strong room at the EC's headquarters. And during his cross-examination, he kept referring to statements, reports that were given to him by Mr. Robert Joseph Metal Nunu, who was with him in the EC strong room representing the petition, and that made it necessary for Mr. Robert Metal Nunu, Joseph Robert Metal Nunu, to also be invited to be cross-examined. Well, his cross-examination was done via video call. Apparently, he made it clear to the court that due to some health issues, he was unable to make it to the courtroom. The court granted that, and permission was made for a video call to be made for him to be cross-examined. Prior to his cross-examination, you will recall that again a matter of controversy did come up. That controversy had to do with whether or not there was somebody with him in the room who could be influencing the answers he might be providing during the process of cross-examination. That concern was raised by Mr. Akoto Ampao. Mr. Akoto Ampao then insisted that the court should ensure that a judicial officer be present with Mr. Robert Joseph Metonunu to prevent him from perhaps getting answers from a third party. And so on. And so that's how far we have come in this. After his cross-examination, then the debate as to whether or not the respondents, the first respondent, said they were not interested in presenting any witnesses because to them the petitioner had not made any strong case that warranted them to present witnesses. The second respondent's lead counsel, Mr. Akoto Ampao, made a similar argument. Of course, the petitioner's lead counsel, Mr. Chachuchi Kota, objected, and the court had to rise, and they will be making their decision today. Mr. Kojo Ponkroma is the Minister Designate for Information. He has come and he's one of the lead spokespersons for the second respondent's legal team, also making his way here. We'll get back to the studio where we will then prepare to start the proceedings in court as the judges prepare to take their seats now. So basically, this is what we are here today to witness in court, the ruling as to whether or not the petitioner's lawyers will be allowed to cross-examine witnesses, or in other words, whether the respondents will be compelled to provide witnesses to be cross-examined by the petitioner's lawyers. That remains to be seen when the judges take their seats. In the meantime, we'll go back to the studio as we prepare for the arrival of the judges.
All right, thank you very much, Abdul Hamid. So that was Abdul Hamid at the Supreme Court. I said that we're waiting for the justices to take their seats, then we'll move you back into the Supreme Court for the hearing to begin. But just again, for you to know, we're going to have two broadcasts. First, it's got to do with the Supreme Court hearing, which is happening now on GTV. The second one, it's the ministerial vetting that will start at 10. That's going to be on GBC News. So we're not going to have the Supreme Court hearing on both GTV and GBC News. GTV will be doing that of the Supreme Court hearing, and GBC News will have the ministerial vetting. The Supreme Court hearing will also going to be live on Unique FM 95.7 and across the 60 regions of this country on various regional FM community radio stations. And we're also going to be on Facebook, Ghana Broadcasting Corporation, on the internet, gbcghanaonline.com. Quickly, let's move to join our resource person, Dr. Kweku Adjournment, who is a law lecturer. He's also the head of Law Center's Gimpa Faculty of Law. Doc, good morning to you.
Good morning, George.
Hope you're good.
I'm good. You just left out the fact that I'm also a lawyer.
Okay. Okay. He's also a lawyer. So Dr. Kweku Adjournment, he's a law lecturer. He's a lawyer.
Okay, you don't have to.
All right. Thank you very much for joining us. Briefly, whatever happens today is going to be the ruling. Do we know what could happen afterwards, after the ruling?
No. I mean, until the Supreme Court gives its ruling, it's difficult to tell what's going to happen. And because we don't want to speculate or preempt anything, we can't say that this is what's going to happen or this is not what's going to happen. What we can say is that we know the stage in which we are, that essentially the petitioner has closed his case and the respondents also decided that they were closing their case. And usually in civil proceedings, when the defendant or a plaintiff closes their case and the defendants also close their case, what is left is for them to file their addresses, which is written statements that in closing, where they want to persuade, or they will try to persuade the court on the basis of the facts of the
Doc, we have to leave it here. I'm sorry about that. We have to leave it here. Quickly move to the Supreme Court. We'll get back to you. So let's go over to the Supreme Court. We'll be right back.
If your lordships please, I appear for the petitioner, and my learned friend Tony Later is with me. He's just a few minutes delayed, but he's shortly here. May it please my lords, Justin Amenuvo appears for the first respondent, with me, A.A. Somoa Asamoah.
Why have you been hiding the Alexander?
Alexander Somoa Asamoah. If it pleases your lordships, I could turn power for the second respondent. My lords, with me are my learned colleagues Frank Davis, Kweku Estrefi, and Yao Pong.
Are they your learned colleagues or your learned friends?
As your lordship pleases.
No, let me know. What's the right terminology? Is it learned colleague when you are announcing
Learned friends, my lords.
This is the ruling of the court. The fundamental issue raised in this objection is whether or not the first and second respondents in this petition could be compelled by this court to give evidence, notwithstanding their express indication to the court that they do not intend to do so. This petition was brought under Article 64, Clause 1 of the 1992 Constitution. The petition seeks to challenge the validity of the election of the President in the 2020 presidential elections conducted on the 7th December 2020. At the close of the petitioner's case, counsel for first respondent announced to the court that the first respondent does not intend to adduce any evidence in the case and therefore wanted its case closed. Counsel for second respondent associated himself with the position taken by the first respondent and reiterated that the second respondent would also close his case because he was not adducing any evidence. Both counsel submitted that having regard to the evidence led by the petitioner through his witnesses, they did not deem it necessary to adduce any evidence in the matter. The two counsel relied on Order 36 Rule 4.3 of the High Court Civil Procedure Rule CR 47 and Order 38 3E Sub Rule 1 and 5 of CR 47 as amended by the High Court Civil Procedure Amendment Rules 2014 CR 87. The counsel for the petitioner has opposed the position taken by the respondent and argued that the respondents, especially the first respondent, cannot refuse to adduce evidence in this petition. The grounds upon which counsel for the petitioner opposed the petitioner's decision not to adduce evidence are that they have both elected to adduce, respondent's decision not to adduce evidence are that they have both elected to adduce evidence in that they have filed and served witness statements as ordered by the court. Counsel for the petitioner argued further that the first respondent in particular, besides filing an answer to the petition, has also specifically deposed to an affidavit in opposition to an application to serve interlocutories in which the chairperson indicated her availability for cross-examination. Finally, it was contended by counsel for the petitioner that the first respondent chairperson performs a very important constitutional function and as such must be made to adduce evidence in his petition to account for his stewardship to the people of Ghana. In their submission before the court, counsel for respondent, particularly for the first respondent, sought to rely on Order 36, Rule 4, Sub 3 of CR 47 and Order 38, Rule 8E of CR 87. We have carefully examined the above rules and our opinion that the provision that is relevant in the determination of this issue is Order 38, Rule 3E of CI 87, which specifically deals with the use of witness statements in civil trials. We deem this rule to be crucial in view of the position taken by counsel for the petitioner among others that the filing and service of a witness statement connotes that a party has elected to adduce evidence at the trial. We recall that the filing and service of witness statement in this case was in compliance with an order of this court as part of the pre-trial protocols before trial commenced. It is also an undisputed fact that a defendant in a case can elect whether or not to adduce evidence at the close of plaintiff's case when such a defendant is called upon by the court to open his or her defense. We are of the considered opinion that it would be wrong in law that a party is deemed to have elected to adduce evidence as soon as that party files and serves a witness statement in compliance with the court order. To hold so would mean that once a party files and serves a witness statement, that party mandatorily has to mount the witness box and adduce evidence at the trial. This position is not borne out of the rules. Indeed, Order 38 Rule 3E Sub Rule 5 clearly provides otherwise as follows. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. End of quote. The above rule implies that when a witness statement is filed and served, the party who files it may choose not to give evidence at the trial. The principle is the same in viva voce evidence where a party or witness who mounts the witness box testifies in chief and fails to turn up for cross-examination. Such a witness cannot be compelled by the court for cross-examination. He suffers the penalty of the evidence being expunged from the record. This is exactly the position the respondents have taken in this petition, where both respondents have decided not to adduce evidence even though they have filed and served witness statements. The above rule also points to the fact that a witness statement filed and served does not constitute evidence in law till the author of the statement mounts the witness box, takes the oath, and prays that the witness statement be adopted as evidence in chief pursuant to Order 38 Rule 3E Sub 2, which provides thus, quote, where a witness is called to give oral evidence under Sub Rule 1, the witness statement of that witness shall stand as evidence in chief of that witness unless the court otherwise orders. End of quote. In view of the clear provisions of the rules referred to above, we do not agree with the submission of counsel for the petitioner that when, as in this case, an answer to the petition was filed at the pleading stage, a witness statement filed, the respondents had elected to adduce evidence at the trial. We are also of the opinion that the filing of affidavit in interlocutory applications with the averment that the deponent will be available for cross-examination does not make the deponent compellable to produce evidence at the trial. Counsel for the petitioner has argued that because the first respondent performs a very important constitutional duty when it is sued in an action such as this case, different rules should be applied. However, counsel failed to refer us to any provision of the 1992 Constitution or any statute which require that the first respondent, being a constitutional body, should be subjected to different rules of the court, and our own industry did not unearth any such authority. The law is that parties before this court must always comply with the no rules of procedure and settled practice regulating the jurisdiction of this court, regardless of the nature of the case. See upon versus Attorney General and others, 1999-2000, Ghana Report 402. The first respondent is not subject to any different rules of procedure because it is a constitutional body. The evidential burden imposed by law on a person seeking to challenge the presidential election results has been settled by this court in the 2013 election petition case entitled Akufo-Addo and others versus Mahama and another 2013 Supreme Court of Ghana Law Report Special Edition page 73. Thank you. After citing with approval several decisions of courts in some Commonwealth countries, notably Nigeria, Uganda, Kenya, and Canada, the JSC concluded at page 218 that, quote, accordingly, the petitioner bear the burden of proof to establish not only that there were violations, omissions, malpractices, and irregularities in the conduct of the presidential election held on 7th and 8th December 2012, but also that the said violations, omissions, malpractices, and irregularities, if any, affected the result of the election. It is after the petitioners have established the foregoing that the burden shifts to the respondent to establish that the results were not affected. The threshold of proof should, in principle, be above the balance of probability. We have started the JSC's dictum to drive home the legal proposition that the petitioner in an election dispute stands or falls on the strength of his or her own case and never on the weakness or otherwise of the evidence of the respondents. Counsel for the petitioner cited to us the case of Small Abiabia versus Ademu Dramani and Attorney General number 4, 2012, one Supreme Court of Ghana Law Report, page 374, in which this court ordered the party to adduce evidence because that party had already adduced evidence in the form of an affidavit. That case is distinct from what is before us now, and it must be read in its context relative to the facts before the court then. In that case, this court was dealing with the submission of no case in a trial admitting affidavit evidence. Unlike the current petition, what this court is dealing with witness statements which are unsworn and are not yet evidence. Indeed, the distinction between that case and the current case is clearly demonstrated in the ruling of Dr. Datiban JSC, who delivered the ruling of the court. At page 357 of the report, the learned jurist delivered himself as follows, quote, it is the unanimous view of this court that the first defendant, Ademu Dramani, should be called upon to open his defense in the interest of justice. This case does not have the ordinary characteristics of a trial, say the High Court. The procedure before this court is such that before the commencement of oral testimony in this case, the first defendant had already put matters in the affidavit. In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first defendant and proceed to an assessment of a no-case submission made on his behalf, as if the evidence on record is that of the plaintiff. End of quote. The distinction here is that in the petition before us, the first respondent has not put before us any evidence in the form of an affidavit or otherwise. As already stated, learned counsel for the petitioner only referred as to an affidavit deposed to by the chairperson of the first respondent in proceeding to an interlocutory application to serve interrogatories. That affidavit is not evidence in this petition to enable us compel the first respondent to mount the witness box to be cross-examined. The Small Abiabia case is clearly distinguishable on the facts and the law. Now, besides the rules referred to in this ruling, we take notice of the well-settled practice that the plaintiff in the case has a right that a defendant in a case has a right not to adduce evidence after the close of a plaintiff's case. This right, which originates from the common law, has been incorporated in civil trials in our jurisdiction through case law and has been applied in several cases in our courts. The general principle of law is that a party cannot be compelled to adduce evidence in a trial. In this direction, we intend to refer to some cases on this principle of law. In Amateur v. Ansan, 1989-92 Ghana Law Report, page 152, Court of Appeal, and PRJ, as it then was, delivered at page 155, that's, quote, the plaintiff contended that since the first defendant did not give evidence, judgment should have been entered against him. I do not agree. A party to an action need not give evidence himself. A party to an action needs not give evidence himself. Provided he can adduce evidence of some sort from other sources, the court would have to look at that evidence in considering the totality of the evidence before it. In Baron v. Labi, 1962, Ghana Report 168, in the practice note, Oluyemi was delivered himself as follows, quote, a party to a suit is not bound to give evidence, and the court cannot compel him to give evidence if he does not want to. And if a party, having gone to the witness box and sworn or affirmed, elects to give no evidence, his opponent is not obliged to cross-examine him. This procedure, therefore, is not irregular and cannot vitiate the proceedings and the judgment in the case. End of quote. In Tai and another FIBA International, 2017-2018, to Supreme Court Ghana Law Report 906 at 919, Forman JSC opined as follows, quote, it must be remembered that the fact that a defendant does not appear to contest a case does not mean that the plaintiff will be granted all that he asks for by the court. The rule in civil cases is that he who alleges must prove on the balance of probabilities, and the burden is not lightened by the absence of the defendant at the trial. The absence of the defendant will aid the plaintiff only when he introduces sufficient evidence to establish a prima facie case of entitlement to his claim. End of quote. In Ama v. Hydroform Limited, 2013-2014, to Supreme Court of Ghana Law Report 1551 at 1567, which was cited to us by Counsel for Respondent Benny JSC, held as, quote, a court has no duty to call upon any party to testify in the case. The courts act as an umpire and only hear such evidence as the parties will prefer. Whether the parties will testify or not is none of the court's business. Indeed, a court to insist that the party should testify will amount to the judge descending into the arena of conflict. After determining the tribal issues, the trial court leaves the field clear for the parties themselves to decide who will testify. We know of no law or rule which entitles a court to call upon a party to testify in the action. If such a law or rule does, we would venture to say that it is inapplicable under legal dispensation. End of quote. Finally, we refer to the case of the Society of Lawyers versus Sir William Otto Jeffrey, BT 2000 Queensbend Division Commercial Court, which on the facts is similar in terms of procedure with the current case before us, incited by counsel for the second respondent. In that case, all the witnesses had served their witness statements in accordance with pre-trial directions under the civil procedure rules, but lawyers had decided not to call them to testify at the trial. An application was made to the court for an order requiring the opposing party to call the witnesses at the trial so that the applicant could cross-examine them. Creswell J. held that in civil proceedings, the trial judge had no power to dictate to a litigant what evidence he or she should tender. There was no obligation to call witnesses. It was counsel's duty to decide what evidence was called and the order in which it was called. The instant court had no jurisdiction to make the order sought. The law is therefore settled that a party will not be compelled to enter the witness box and testify in support of his or her case. It is a risk parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the state of law case to the peculiar facts of this petition, because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Laws case like this petition also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are amended to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64, Clause 1, challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
As the court pleases.
We are most grateful to the court. And also we are most grateful.
Please, you rise for about 20 minutes.
My Lord, yes. Respectfully, before you rise, I think I ought to notify your Lordship that we will now seek your Lordship's permission to reopen our case in order to have a subpoena on the chairperson of the Electoral Commission. Now, my lords, we know that we can issue a subpoena without leave, but since we have closed our case on the assumption that you would be, so we intend to file a formal motion.
Counsel, it's a court of record, so like you have correctly pointed out, you come back from you'll be heard.
Very well.
Yes, but you come back and give directions for the further trial.
All right, welcome back. So that's was the ruling, and you've heard it coming from the presiding judge, that's the Chief Justice. The witness for the second respondent is not going to mount the witness box. Again, for you to know that the Supreme Court hearing is live on GTV, and Ministerial Vetting is also live on GBC News. Sure. So the Supreme Court hearing is live on GTV. The Ministerial Vetting is also live on GBC News. And the sign language interpretation is provided by Youth Bridge Foundation and the National Council on Persons with Disability. We're also live on radio. We are live on Unique 95.7 in the Greater Accra region, and live across the 16 regions of this country on our various regional and community radio stations, and on Facebook, Ghana Broadcasting Corporation. The judges have just risen for just 20 minutes to see how best we can work with that 20 minutes and take you back to the Supreme Court. We've been joined via Zoom Dr. Kweku Ajiman-Budu, who is a lawyer, he's a law lecturer, and the head of Law Sector's Gimpa Faculty of Law. Doc, once again, thanks for joining us and thanks for your patience.
Thank you, George.
All right, help us to understand what just happened, although I've just given the final line that the presiding judge gave out, but help us to understand exactly what happened.
So what happened was from the discussion we had the last time we met, and basically there were two competing arguments from both sides. The petitioner was arguing strenuously that to the extent that the respondents had filed their witness statements in compliance with the Supreme Court's directions to file witness statements, if any, then they had elected at that point in time to produce evidence. So there was no question as to whether or not a defendant can decide not to adduce evidence or open their case. It seemed clear that all parties were on an equal footing or understood that particular principle, that it was open to a defendant or a respondent in this case not to adduce evidence at the close of the petitioner's case. The question then now was whether, having filed and served those witness statements in compliance with the Supreme Court's directions, did that mean that the witnesses were going to be called, or that did it mean that they elected to call witnesses and at all costs they had to call witnesses who would then be subsequently cross-examined? That was the position of the petitioner, that the election took place at that point when they chose to comply with the Supreme Court's directions. The respondent, on the other hand, will have the opinion that on the basis of the rules, or the 38 Rule 3E of the High Court Civil Procedure Amendment Rules of 2014, CI 87, that they could, even though they had filed the witness statements, they could decide not to call the particular witness or witnesses to actually testify. And to the extent that the witness statement was not yet in evidence, they could not be compelled to at all costs open their case. And this was the sticking point between the two parties. And we just heard the Supreme Court deliver its ruling on this particular matter, where they essentially uphold, or no, they overruled the objection of the petitioner in terms of the respondents deciding not to open their case or not to adduce any evidence. They cite, or the 38, in actual fact, they say that the critical rule that is applicable is on the 38 Rule 3E of the 3E5, I believe, of the High Court Civil Procedure Amendment Rules, which provides the opportunity for a defendant or a respondent in this case to file a witness statement but decide not to call that witness to testify or even put the statement in as hearsay evidence, whereas or whereupon an opportunity will then be on any other party or available to any other party to then decide to put in that witness statement as hearsay evidence. So in a nutshell, the Supreme Court has overruled the objection taken by the petitioner in relation to the respondents not opening their case or deciding to close their case and not adduce any further evidence.
Okay, so as we speak, what's the available evidence in front of the court now?
So the evidence that the court has is what has been adduced so far. And the court made mention of the fact that the burden of proof is so that's the evidential burden of persuasion is on the petitioner, and it has been settled in the 2013 election petition. So you heard the Supreme Court cite, I believe it was a quote from Adjournment, GSC. Yes, precisely, where she suggested that the burden was on the petitioner in an election petition of that nature to prove that on the basis of the evidence that they have, there were irregularities, malpractices, and all that. And once they've done that, they need to, once they've been able to establish that, then the burden will shift to the defendant or the respondent to also adduce evidence to possibly refute that assertion that would have been made by the petitioner. So generally speaking, that burden is on the petitioner in a case, in an election petition case of this nature. So what options are available right now in terms of the evidence are what has been adduced so far. the testimony of the witnesses that have been called by the petitioner. You remember the petitioner has called 3 witnesses, Mr. Johnson Asiedu Nketia, Dr. Pesa White, and I believe Mr. Robert Joseph Metonunu. So, and through their testimony, evidence has been adduced. They've tendered in evidence of some sort in terms of some documents that they wanted to put on record, some videos as well, and things of that nature. So the totality of the evidence we have right now is what we have been witness to so far when the petitioner opened their case. So that is the evidence before the court right now.
Okay, just give me about 2 or 3 seconds, or even 5 seconds, for our viewers and also listeners to know that we are live on GTV with this Supreme Court hearing. That's the petition. For the ministerial vetting is live on GBC News. Ministerial vetting is live on GBC News for the Supreme Court hearing, which is happening now. So the pictures you're seeing now on your screen is coming from Parliament, which has got to do with the ministerial vetting, which will take you over. But for now, on GTV is the 2020 presidential petition, which is currently going on. And there's a break for just 20 minutes. Morris.
All right. So we still have Dr. Ajimambudi on the line. Doc, so apart from the 3 witnesses who have come to witness on behalf of the petitioners, the petition itself that was filed by the petitioners, is it also in evidence? Is that evidence?
So the petition contained pleadings, the allegations of fact that the petitioner was making, that this and this happened, and that the chairperson declared in error, or there were errors, and all those kinds of things. So those are the pleadings that they specifically put in their petition. And as we've explained before, those pleadings in pleadings you're not supposed to generally plead law. Of course, you can plead a point of law as to jurisdiction and all that, but generally speaking, you're supposed to plead facts. And after you have pleaded your facts, when you open your case, you will then adduce evidence that will support those facts or substantiate those facts. So that's why there needs to be a connection between the pleadings and the evidence that you adduce. And that's why we've seen in these proceedings that the court has struck out certain pleadings or certain allegations, for instance, not pleadings necessarily. If you look at the witness statements that have been put in and the testimony of the witnesses, we saw that, for instance, with Mr. Johnson Asiedu Nketia, there were certain statements in his witness statements that were objected to, that the court struck out, and on several, or for different reasons, one of them being that they were not pleaded to, or they are not supported or grounded in the pleading. So the testimony that your witness is going to give is supposed to help you substantiate the pleadings that you would have made at the beginning of the case in the petition. So there has to be a connection between the evidence or testimony of the witness that you have called and the pleadings that you have made. So that connection will help you establish or substantiate the facts that you are alleging. And so that is what the petition is. The petition itself contains the facts that you are alleging or the pleadings in your or that you have made, and you need to then call witnesses or adduce evidence through those witnesses to substantiate those facts. So the pleadings from their own is not evidence. It is the testimony of your witnesses and the evidence that is adduced, which is connected to the facts that you have pleaded. That is what helps you substantiate your pleadings or your facts.
Right. So now that the Supreme Court has told us that by filing the witness statements at the case management level by the respondents did not constitute an election to adduce witness, and for that matter present their witness to be cross-examined. Now, by way of education, at which point would they have been bound, to, as it were, adduce evidence? At which point?
At no point, and for the simple reason that the defendants in civil suits reserve the right whether to call witnesses to testify on their behalf. And it goes to the issue of burden of proof in civil cases, which is on the balance of probabilities, that you, the one alleging that or suing someone or bringing a case against someone seeking specific reliefs, there's a burden that is on you in the first instance, and that's why the 2012-2013 election petition was cited. There's a burden on you to adduce evidence that substantiates the allegations that you are making. And if you are able to do that, then the evidential burden may shift or can shift to the other party or the defendant in that particular suit, then to also call evidence. But even in that case, the defendant can decide that they won't adduce any evidence. They are not, it is not by force that they have to, at all instances, defend the suit. And in this particular instance, what the respondents were saying is that on the basis of the evidence that had been adduced so far, they do not believe that the petitioner has discharged his burden of proof, that he has met his evidential burden to warrant them to even open their case. So what they're saying is that essentially their case should stand or fall on the basis of the evidence that's before the courts right now, and they choose not to adduce any further evidence, which means that the court should be able to decide the matter on the basis of the evidence that they have before them.
All right, Doc, the evidence before the court now is the petitioner's evidence, right?
Generally speaking, yes, because they called evidence first. They made their case first.
So the first and second respondents don't have any evidence at all in court?
Not that they don't have any evidence in court. They are choosing not to call evidence. They're choosing, you remember that during cross-examination, for instance, they sought to impugn the credibility of some of the witnesses and all that. They sought to introduce certain documents. They sought to play videos and things of that sort. But what we can say is that the burden at that point was on the petitioner. So it's not as though to suggest that it is all the evidence in the case is from or emanates solely from the petitioner, but generally it was the petitioner's duty to call evidence in the first instance, after which the defendants or the respondents will decide whether or not they will call evidence on their own behalf or in defense of whatever it is that has happened at that particular point in time. But they believe that on the basis of the evidence so far before the courts, the totality of the evidence before the courts, that the petitioner has not met his evidential burden to warrant them to even open any defense whatsoever.
And who is to determine whether the petitioner has met its evidence burden or not?
Well, generally speaking, it will be the court that will determine at the end of the matter. But the petitioner, so for instance, there's what in civil trials is referred to as a submission of no case. So a submission of no case is essentially where the plaintiff has closed this case and the defendant will decide that on the basis of the evidence adduced so far, the defendant has no case to answer. So they will make a submission of no case where they are put to an election. Election one, but there was no case. Again comes in here. They are put to an election to either stand or fall on their submission, which means that if their submission of no case fails, then the matter ends there, and then except of course if the court decides otherwise. So it's possible to say on the basis of everything that you've done, I don't think you've discharged your evidential burden, so I won't even bother to open evidence, and I'm making a submission of no case. The court should decide on the basis of the evidence that has been adduced so far that generally has come from your end. It is not unusual for that situation to occur in civil trials of this nature.
Now, for something like this, and to determine the final outcome of a case, is it a risky position or a risky card to take if you are a respondent in cases like this? Because in reading the judgment, you heard the Chief Justice saying that, every responsibility is on the respondent based on the consequences that comes out of the decision taken. What's the risk in such a decision?
it may be risky for defendants in a civil suit generally to decide not to call evidence. But once again, it's not a question of strategy, it's a question of what you believe, because...
Hello? Doc? All right, looks like we're having challenge.
Yes.
Can you hear me?
Yes, I can hear you clearly.
All right, so please go on. Your last,
yes, I'm saying that it... Yes, I was talking about the risk. You were asking about whether there was a risk.
Yes.
Yes. So what I was saying was that it all depends on strategy, and it depends on what you deem appropriate at that particular point in time. So if you're a defendant and you believe sincerely that on the basis of the evidence that you so far by the plaintiff hasn't even made any case in the first place to warrant you to even open a defense, you take that risk to not call evidence. So what happens is that the court will decide on the basis of the evidence that is before it, which would have at that point been generally adduced by the other side, the plaintiff. And so it's a risk in the sense that if the court finds that the plaintiff's evidence shows that they made their case, essentially the plaintiff has won that particular matter, or the matter will be decided in their favor. So that's the risk involved, because if you choose to call evidence, then you are seeking to sort of disprove or counter whatever evidence has been adduced by the other party. But if you sincerely believe that the other party has not even met their evidential burden, which at the end of the day, like I'm saying, it is the court that will ultimately decide. But you can take that risk and say, I'm not going to call any evidence. The court should decide on the basis of everything that is before it. And so that is what it is. It's possible for you to take such a step.
All right. So we have to go for a quick break. When we return, we'll look at the other options, which was outlined by the counsel for the petitioner, and move into other areas to just... we'll be right back. Just leave us. We're going for a quick break. We'll be right back.
Powers and principalities.
There's so much fire inside me.
Tragedy struck when part of the largest hillside at the kosher rubbish dump collapsed.
It's going to be fun to see how he goes about approaching this game.
powers and principalities.
There's so much fire inside me.
Tragedy struck when part of the largest hillside at the kosher rubbish dump collapsed.
It's going to be fun to see how he goes about approaching this game.
Addressed to the chairperson of the Electoral Commission of Ghana. And we believe that those processes are necessary processes that would have to be heard and determined in this case. We also intend, subject to receiving a copy of the ruling that you delivered this morning, we also intend to apply for review of that ruling. And that application, we believe, would also have to be heard in order. Very well, my lords, we're drawing your attention to it because we believe your lordship should take that into account in whatever directions you give. We do not think that it would be appropriate for us to have to be bringing applications for stay of proceedings and so on. I mean, we can do that, but it may be better to avoid going through all those different processes if your lordships would allow us the opportunity to file and have those processes determined.
With all due respect, we cannot prevent a party from filing processes. When a process is filed, the court will come and hear it. Whether it is review, whether it's stay, whether it's an application to reopen the case or whatever, you will come and hear it. But these are the directions. Yes, by court, by the ruling just read, the respective cases of the first and second respondents are deemed closed. This court hereby orders that the parties herein should simultaneously file their respective closing addresses or submissions on or before the 17th of February 2021. The petition is hereby adjourned to the 18th of February 2021 for counsel in this petition to highlight on the written address or submission so far for the petition to be adjourned for judgment. So we will come here on the 18th of February. Yeah.
My lords, there is also a matter which arose in connection with your issue 2, and I wonder whether that has been resolved. I think we should, as a matter of record, know. My lords, when we come when?
Based on the data contained in the declaration of the first respondent of, not for, of the second respondent as president-elect, no candidate obtained more than 50%.
Can your lordship over there again respectfully?
So, whether or not, based on the data contained in the declaration of the first respondent of, not for, of the second respondent as president-elect, no candidate obtained. So it's simply that the for
should be off.
should be off.
That's
That is the only correction.
Welcome back, and so we were going back to court on the 18th of February. Between that time to the 17th, they are allowed to prepare their final legal argument, addresses final arguments and all that will address the courts and submit it by the 17th. And then the 18th, the court will sit. But before that, you heard counsel for the petitioner raising a couple of issues that they wish to file an application for review of the ruling, an application to reopen the case, and also to subpoena the chairperson of the Electoral Commission. And that's what just happened.
Right, but the Supreme Court has given indication that even though the petitioners have indicated that they would like to open their case, the two cases have been closed accordingly.
Yes, for the first and
second.
The three actually.
Sure, I mean the cases have been closed accordingly.
Yes.
And so we'll wait till the 18th and see when the petitioners bring their application for a review of this particular ruling, and also an application for an opening of their case, and also to subpoena the Electoral Commissioner to appear in the witness box.
That might even be before 18th, though.
Okay, that will be before.
It might be before 18th.
Sure.
Because the court said that for them, I mean, if you bring in application, they can't stop you, but they can actually hear. Right. Let's move on to talk to Dr. Adjournment, and he's joined us back. Doc, are you there?
Yes, Jordan.
Yes.
Yes, I'm here, Jordan.
Okay. Before we went for the break, and before we went back to the Supreme Court, I said that we'll be looking at the options given, especially stated by the petitioner or the petitioner's lawyer. First of all, if someone closes his or her case, on what basis can the person reopen the case?
I mean, as the court rightly pointed out, we can't decide for the parties what types of applications they can bring before the court or not. Their role is to adjudicate one's applications before them. So if parties have closed their cases, like I was saying earlier on, you may see the leave of the courts. And for instance, if we can just give an example, in terms of the witness statements, we know that the witness statement is not evidence until the person who filed that witness statement has been put in the box, so the person who signed that witness statement has been put in the box. But we also know from the Supreme Court's ruling today that the party who files a witness statement can decide not to call that particular witness to testify. And if they decide so to do, either they can also decide not to also put in the witness statement as hearsay evidence. It will be open to the other party. So plaintiff, for instance, in a civil suit, may then probably, if they close their case, may then seek the leave of the court to reopen their case and try to tender in that witness statement through maybe one of their previous witnesses as hearsay evidence. So that would be an example of a situation that can happen even though the case has closed. But once you rightly know that an application will have to be made and the court will have to grant leave for so doing.
Okay, all right. And like we stated earlier, that hearsay evidence is not admissible.
Generally speaking, hearsay evidence is second-hand evidence, not admissible, but there are exceptions to the hearsay or the rule against hearsay evidence, and this is one of the exceptions where a witness files the witness statement but is not called to testify and does not put it in as hearsay evidence. The other party can put that witness statement in as hearsay evidence because it is not the testimony of that other party's witness, but the other party's witness is putting it in as the testimony or the statement, let me put it that way, that was made by a potential witness. And because it is not first hand, and because that person who filed that witness statement is not available or is not being called to testify so that he can be cross-examined, that statement can only be put in as hearsay evidence. So that would be one of the exceptions to the rule against hearsay evidence. There are other exceptions, lots of exceptions, actually. Admissions, for instance, confessions, I believe, and other exceptions exist in terms of hearsay evidence.
All right, and the counsel for the petitioner also talking about subpoena. Exactly help us to understand this process too and what it means.
What, can you take that again?
The counsel for the petitioner talked about an application also to subpoena the chairperson of the Electoral Commission. Help us to understand what this process actually means.
So that's one of the questions that people were even speculating about even before today's ruling. And so it's a discussion of subpoena, what a subpoena is, and even it goes beyond that to even the issue of compellable witnesses. So a subpoena is simply a document or an instrument which is issued by a court to summon an individual or a person to appear in court proceedings, either to testify and or produce a document which is in that person's possession. So if we look at the Courts Act, for instance, Section 58, I believe, of the Courts Act of 1993, Act 459, it provides, and I'm trying to paraphrase here, that in any proceedings and at any stage of the proceedings, a court, either on its own motion or upon an application by a party to the suit, may summon a witness to attend, to give evidence, or to produce a document in the possession of that particular person, or even excerpts from that document. But this is subject to the applicable enactment or a relevant rule of law. And so what this generally means is that it is generally possible for a court to summon a witness or witnesses either on its own, so the court will exercise its power suo motu, or upon an application that is made by a party. But we need to note, most importantly, that this is discretionary according to Section 858 of the Court Act. It's discretion. That's why it says the court may either on its own motion or upon an application of a party. So it's not necessarily as of right. So such summoning of witnesses in relation to proceedings, if it's before the High Court, for instance, if it's a matter before the High Court, and assuming an application of this nature is made and is successful, what will be done is that it will be done pursuant to Order 38, Rules 10 to 13, I believe, of the High Court Civil Procedure, CI 47 of 2014, where a request has to be made for the issuance of the writ of subpoena from the registry of the courts from which you seek that writ, or from which that writ is to be issued. And once this is properly done, a writ of subpoena ad testificandum ducis tecum will then be issued in the prescribed form. I believe it is Form 14, which can be found in CI 47, and it shall then be sealed and it shall be served personally on the person to whom it is addressed within 12 weeks, I believe, from the date of issue.
Doc, let's briefly hold on here. We'll go back to the Supreme Court for the press conferences organized by the two political parties, the NDC and the NPP. So let's go back to the Supreme Court and hear out what the two parties are going to say. That's the NDC and the NPP. Their after-court proceeding press conference. We'll be right back.
You do the trade.
Are you ready? Are you ready? Okay. Good morning, ladies and gentlemen. Well, I don't see any ladies. Okay, so good morning, gentlemen. I believe you all followed the proceedings today, and of course, starting from Monday. On Monday, the petitioner closed his case after calling 3 witnesses. After closing his case, the respondents, per their counsel, informed the court that they had elected not to mount the witness box. What this means is that, or what that meant was that the chairperson, Jean Mensah, and the representative of the second respondent, Mr. Makmenu, were not going to mount the witness box to testify and be cross-examined by counsel for the petitioner, Mr. Chikata. You will all recollect that they had filed witness statements in the case. So naturally, counsel for the petitioner opposed this request or application by the respondents on the grounds that not only had they filed the witness statement, but by 2 affidavits by which they opposed our request for them to answer interrogatories and for them to produce certain documents. The chairperson particularly had said that she would be available for cross-examination. Now, the petitioner's point was that under the specific rule, Order 36, they had elected by this particular conduct to adduce evidence in court, and therefore it was no longer open to them. Insipid arguments by the respondents. Nevertheless, the courts have ruled in favor of the respondents, saying that they do not agree with us, that even though this is the EC, a constitutional body, the same principles that are applicable to ordinary people should be applicable to the Electoral Commission, and therefore they were upholding their request not to mount the witness box. Subsequently, also heard Mr. Chikata. He said, well, if that is the decision of the court, then he's going to apply. In fact, he's in the process of filing an application for us to reopen our case and to subpoena the chairperson of the Electoral Commission. And so that is the status now. So now, for us, those are important, there are important lessons to be learned from this. Now we have an EC who, when a request for information was served on them in the past, they refused to respond. We have an EC who was requested to answer interrogatories. They refused to respond. We have an EC that was served with an application or a notice to admit facts. They refused. We have an EC that was asked to produce documents relating to the election. They also refused that. That's the kind of EC we are dealing with. I mean, where are the principles of accountability? When is this EC going to be accountable? Any questions?
Yes, ma'am.
Counsel for Petitioner also announced that he will also file an application for review of the decision of the court. So that's 2 applications he will be filing.
I'm sorry, review of the decision we had today.
Today's decision.
Okay.
He will apply for a review of that decision.
Okay, so maybe that even gives me the opportunity to ask this question. You have described as superior the argument made by Mr. Chikata against the application, and as wishy-washy the argument made by lawyers for the respondents.
Yes.
How would you, in that position, describe the ruling that we have from the court today?
The ruling is the decision of the Supreme Court of Ghana. We have nothing to do but to accept it. We disagree with the decision, and so we are going to file an application for review.
Madam, now that the court has set the 13th for all parties to submit their addresses, now that the court has set the 13th for all parties, 15th for all parties to...
Okay.
You file by 17th and your addresses, and the court comes back on the 18th. We know, as you said, you made an application or filing, you are going to file an application for a review, file another application for your case to be reopened. When you write your addresses and it's brought before the court, what becomes of these 2 applications, especially the one for you to reopen your case? Because then by the time your addresses would already be provided to the court. And what's next is that the court gives directions on it for ruling.
Well, you heard his lordship. He said that nobody can stop us from filing an application. When an application is filed by a party, the court will deal with that application. And so we expect that the Supreme Court will take into consideration all these issues when dealing with the application.
Thank you very much, Madam. The Supreme Court was very clear in its ruling. It said that...
I can't hear you.
I'm saying the Supreme Court was very clear in its ruling. It said that a petitioner in an election petition case stands on its own strength. And not as the respondent's witness. Is that what he sought to do?
I didn't hear the last.
I'm asking if that's what he sought to do. I mean, using the respondent witness to make your case.
Definitely not. We have the strength of our case, but as we have stated over and over again, the EC is accountable to us. She has to account for how did those errors arise. When did she discover those errors? What was the process of correcting the errors? We've seen for some regions there are different summary sheets, different collation sheets. How did that come about? Who's going to answer this? Apart from that, remember that the petitioner is not the returning officer. The petitioner does not declare results. It is the EC that, or the chairperson, that declares results in presidential elections. Does that answer you?
Well, my question is a follow-up to my brother's question. In giving their responses as to why the first and second respondents will not let their witnesses come to the box, the reason they gave was that the petitioner had not made a case strong enough to warrant them presenting any witnesses.
That's not what the Supreme Court. I didn't hear the Supreme Court say that.
Well, I would like you to give me your understanding of but that's how I understood it.
I never heard them say that.
That was what the lawyers, the lead counsels for the respondents, first and second respondents, one of the reasons they gave was that the petitioner had not made a case strong enough to warrant them presenting witnesses in the box. If that's not the case, I would like a response from you. As what you understood.
As simple. If we disagree.
Well,
as simple as that.
Because then my question then would have been.
You've heard counsel for the petitioner on Monday. And we disagree with that position. That the evidence that has been given points simply to the fact that that declaration of 9th December is null and void. None of the two candidates got more than 50% of the valid votes. There's only one declaration, 9th December declaration.
So the petitioner...
There were purported corrections. Have you seen any gazette notification dated on any of the purported corrections, the dates of the purported corrections? There is only one, 9th December, and the CI 135 talk about a declaration of 9th December.
Okay, so then, Honorable, if the petitioner does not get the chairperson of the EC to respond, does that then make your case a dead case? Because you seem to insist that she must, by all means, respond to certain questions.
And we will insist. We'll cross that bridge. But I believe that the petitioner has made, we are convinced the petitioner has made a case.
Well, so the question is, if you are very sure in your case, why then the insistence on the EC entering the dock, why would you not just allow the court to rule on what evidence has been availed to it so far?
I can't hear you.
I was saying that if you believe in the petitioner's case, why then the insistence on getting the EC, the chair of the EC, to enter into the dock? Why not just allow the court to rule on what matters in the dock?
Why don't we allow...
I am asking why the insistence on getting the EC to enter into the dock, because if you are sure about the petitioner's case, why not just allow the court to rule on your case so far, since the respondents are withdrawing from?
That there are questions that we put to her that only she can answer. Nobody else can answer. Irrespective of what case we have put before the court, there are questions in relation to this case that she alone must answer.
All right. You keep saying that you are depending on, you're not depending on the witnesses of the respondent.
We are not what?
And that you have your own special case. Can you tell us the exact case you are standing on to deal with this petition?
Have you seen the reliefs have you read the reliefs?
Yes, I am saying that you just said that you are not basing, or you are not even expecting the witnesses to make a case.
I answered the question that there are specific questions that she has to answer. It's as simple as that.
Let's do some 5 minutes. Yo, anyone? I'm say, and your bar court as Citrano. As someone at the court, a nimpa or say, Ubua, and say, a year managing Mensa, or dinner on my electoral commission. I will say, Oba Adakanum, no Babiina, no ana. Munim say, Nano Juada. Yema a lawyer for ina kwa mobia kanasem na mu ina nsutie nsema eye lawyer chachuchi kata odina homa eye petition no odi tudwa e wo court ewie chire no ye kani ina bomu na ye baaye no ne ya court e ka kire ne se oni yen enya bin se maame no ebeba abetina adakanum na ade a wo ne se in some misedi wo wa ye bia tudwa edi kan ye bisa ye no ono asem odi betu kote numa wedi si atachire ose ye ba cross examination obeyi no na samba ye inspection ye ko nkrata bim ose ye ba cross examination obeyi no na se ye du se brabetna de kan no mbisa wa o se memma menko adakanum nanso court enyebua say on no de on the woman ya say maame no monko adakanum enti ama ye lawyer penny enso dia to court na nim say ne omo kan no won wo nya adwen enti ye besan eden krata ba wo nim asra se omo nsan hwa asem no biom ye ye no nso fi wa ye sa be sre court no say esense ni ye close ye case ana ye wie case ansa na ma me no ka say on ma da kan mu nti ye san be bie ye case no so na ya subpoena no ye ka say subpoena ya makota sheno se on ma da kanum na nsem wo so yi na ese so no kwa na returning officer o Ghana nsem se bisa no bi ntimi yi no kire ono de mensa no betime yi no enti e ba makota asheno e di subpoena atoa no akwa sheno so mra da kanum no ma be nsem na no enti we ni nsem mienu a ye lawyer for the to court enim se ye di omu maame no beba adaka adaka ne de ye gusu gina be bi na se maame no so twa no okupa no awo se maame no oba be gina adaka no so nya boni bia na so onfa bibia nsie de a adaka ne de ye be gina na so se omra emegina adaka no nti be bia gina ene nsem mienu a ye de atudwe eno de akira ansana MPP fonso aba MPP fonso so omo ba no mbe omo be yi omo mpo eno so omo ba na omo be ya send ye general call no ye hwe nim se magmenu nso baba ba mi se magmenu twetwe ne nase but wuni ekosi an se ye de nsem ye no atukot nenim 2 applications ye de baba court nenim na me ya aduma ya se bie ye nsem no so na ya frem ame no na obegina de kanim medam wase.
Thank you, Bob.
It's not for me.
Jewish. Not to bring myself up.
Your mama.
The general.
Colleagues, good morning. I think it's been one of the shortest days in court so far. We have some remarks to share with you. I want to start by quoting about 3 or 4 things that the Supreme Court of the Republic of Ghana, speaking through His Lordship the Chief Justice, put out today. First is that the law is settled, that a party cannot be compelled to adduce evidence under the circumstances that we are discussing. The law is settled on that matter. And you notice that the Supreme Court spent some time to educate all of us who are interested in the legal profession or are following this case on the various cases in times past when the courts have ruled, sometimes up to the Supreme Court, that that is the position of the law. Nyamiche versus Ansa, Bamo and Labi, and another, AMA and Hydrofoam Estate Society of Lawyers, they went at length to remind all of us that on several occasions, the courts have had to lay down this rule, that the law is settled. So if anybody comes with some new arguments as though it is a gray area of the law, or that it is possible to compel a party to produce evidence in circumstances like this, the law is settled, that cannot happen. The second point that the Supreme Court has made, which I think is very important for us, is that a case is won on the strength of the plaintiff's case and not necessarily on the weakness of the defendant's case. A case is won on the strength of the plaintiff's case and not necessarily, even if so, on the weakness of the defendant's case. So this suggestion that the defendant, or in this case the respondents, must mount the witness box to enable the petitioner complete or strengthen or make a case is contrary to what the law and the practice has been for all of these decades. The third point that the Supreme Court has made today, that it has heard all of these arguments about she holds a constitutional office, the EC is a constitutional creature, and therefore there must be accountability. You remember that even for us speaking to you last week, we said if you want accountability, let's all go to Parliament, whether it's Public Accounts Committee or a parliamentary inquiry or something. But when you come and you apply to the court under some specific rules,
you don't fail to meet that standard and then resort to that general argument. The court has said something about it, and I think we need to take note of it. It says that the fact that she holds a constitutional office and that there's a constitutional responsibility involved does not mean that a different set of rules must be made up. Now, I think it's very significant that the fact that she holds a constitutional office or that there are constitutional responsibility questions that are being raised does not mean that a different set of rules should be made up. So today, the question that the court invited us so that it will answer whether or not a party can be compelled to adduce evidence, the court has answered it and has given the many instances in which it has arrived at this similar position. Now, you remember that our colleagues on the other side opposed our statement to the court that we were closing our case. And please let me just take you back. They made their case and closed their case. When it was time for first respondent said that first respondent was also closing its case and did not intend to invite anybody to adduce evidence. And that closure took place. Second respondent did same. So all three sides have closed their case. That was when they objected that we cannot close our case and they cannot close their case until they bring in the EC chair to be cross-examined. And they opposed on three grounds. That they are of the view that she has already elected, or the EC has elected to adduce evidence. And you heard the long submissions that were made. Even our colleagues who came before you tried to make a new case that election happened when the court gave orders for the filing of witness. Today the court has settled that matter, that is not true. The court gave an order that we should file witness statements. We even complied. They did not comply. The court had to give them leave to come and do it a second time. Compliance with those orders does not amount to election to adduce evidence. The court has settled that question. This other argument was made that because of some of the averments in her affidavit, it amounts to evidence in the substantive matter before the court. The court has explained that the affidavit in interrogatories does not amount to evidence. The affidavit at the interlocutory level does not amount to evidence in the substantive matter. And I think it's a major point of law that all of us who are following should now follow. And I think this conversation of constitutional rule and accountability has been dealt with. Now, the Supreme Court has also reminded us of the threshold of what an election petition has to be. You heard the court speaking through the Chief Justice refers to the ruling of 2013 that the party petitioning must show that A, not only were there violations, but the said violations affected substantively the result of the election. And that you have to establish this. It is after you have established this that the burden of proof shifts to the other side. And that you stand or you fall on your own case. And then very finally, you notice that the court was at pains to point out that sometimes some of the cases we have been citing are of no moment to the matter before the court. Sumaila Bilbil was raised. The court said it's of no moment in this matter. It has to be distinguished. Remember the last time they cited Elis Tamaklu. The court said it's of no moment to the matter we are discussing. So we think that it is important that some key attention is paid to some of these issues. Right now where we are is this. The petitioner who petitioned the Supreme Court that nobody won the election and that he has 5 witnesses to prove that nobody won the election. He's got 3 of the 5 witnesses and in the end has closed his case. The first respondent said, I don't have any witnesses who I think have to respond to this opposite case. And so I don't intend to adduce evidence. So I close my case. Second respondent has said same and has closed its case. And now the court has given orders for when we should bring our written submissions. Our lawyers have started working on that. We hope to meet the deadline that the court has put out. The petitioner is now informing the court that he intends to come with an application to reopen his case. Of course, that application to I'm calling all 5 witnesses. Call 3. You saw how the three performed, whether or not they addressed the issues before the court, and was not forced by anybody to close his case. Was not directed by anybody to close his case. Voluntarily announced to the court that, my lords, we close our case. Our case is done. We have closed that. We've made enough of the evidence that must be made available to you. So our case is done. Now is telling the court that he wants to reopen his case after the court said you cannot use the first respondent to make your case. And they are even signaling that if they are successful in reopening the case, what do they intend to do? They intend to subpoena the second respondent. Why? To come and make their case for them. Sorry, the first respondent to come and make their case for them. It is becoming clear, particularly to the NDC supporters across the country who have been believing everything they've been saying along the line. First they said they won, then they changed it to they didn't win. In the last 1 week, right before you, they've been changing the argument that it's a constitutional accountability matter. And it's not so much about who got 50%. My learned senior Dominic Ayine has been saying that before you every day. There is a constitutional interrogation that they need to do. And that is it's a constitutional matter. 3 different cases. They keep changing the goalpost. And that is why you had the court, I think, refer them to the base on which we're here. So we continue to say that we're in the hands of the court. We will bring in our submissions by the deadline and pray the court to dismiss this petition before it. We'll take your questions.
Okay, so Mr. Minister Designate, I'll ask the first question. My name is Wilbur Fasari. I work with Asasi Radio. When the Supreme Court started its ruling today, it started by quoting Article 64(1). And it says that this whole case is about this article. We've been in court for 14 times, and we've been hearing that this case is about so many things. Why is the Supreme Court saying that this case is essentially about 64(1)?
I will borrow the words of my learned senior Dominic Ayine. I think somebody asked a similar question a few days ago, and then he said this is not a debt collection matter. You recall? This is not a debt collection matter. And that this is not a case between some plaintiff and defendant. It's true, he's right. But what it is that this is a challenge to a presidential election under Article 64(1). And the court has explained what that animal is. That you come before the court and you say, my lords, I'm challenging the validity of person X as having been elected as president-elect and therefore president of the Republic. And the Supreme Court has explained what you must meet. The point the court is making is that that is what you came to tell it in the beginning. And therefore, all these proceedings are supposed to be within that confine. They are therefore looking out for the evidence you are used to make that case. Not this new afterthought argument of accountability, constitutional responsibility that is being made. Accountability, constitutional responsibility is not Article 64(1). It's not, respectfully. Accountability matters. And to the supporters in particular, your leaders are continuously changing the goalpost and are not meeting the evidence thresholds and standards that they have to meet in. So if the Supreme Court goes back there, we think they are guiding all of us that this is why you people claim you came to court. Let's take within that confines.
Thank you very much. If the action of the petitioner succeeds in court, i.e. leave to subpoena and application to reopen case, would you as second respondent be compelled to also ask for leave to reopen your case?
Well, there are a number of options that are out there depending on the court's rulings as they come. We are of the respectful, humble view that, as the court said today, the principle is that you cannot compel a party under these circumstances to adduce evidence. If you prove some fresh evidence and extreme circumstances under which your case should be reopened, And then you come with your second application for subpoena. What is that subpoena supposed to achieve? To compel the person that the court has said cannot be compelled to give evidence. The subpoena is now to compel that person to come and give evidence. We think it will be an interesting set of arguments. But wherever it goes, as we have said, if it becomes necessary that we put witnesses in the box to respond to issues, we are more than happy. I keep telling you that Chairman McMahon comes here every day prepared that if they cross a threshold, then we have to do that. We'll do that. But as you have noticed, unlike the petitioner who, as some of my colleagues have been suggesting, appears to be abandoning the case because he's been here twice, we are always here. If it becomes necessary, we'll be happy to mount the box. But now it's also becoming clear why we filed a submission of no case. Because on the face of the petition, it was, the preliminary legal objection, okay, that this is not an election petition properly so-called. It was clear on the face of the petition. And that is why we put in that application. Perhaps if we had even struggled to go and put in witnesses, we would have been undermining that submission. That submission is still before the court for the court to consider. And so, depending on what the court decides to do, our senior lawyers will take, their next line of action. Indeed, I have heard conversations. I don't know if I have their permission to say this. I've heard conversations by some that if they elect to subpoena the EC chair, maybe we should also elect to subpoena the petitioner to be brought into the box. I don't know if they will agree to it at the end of the day, but it is part of the various, conversations. We'll see how it goes. Yes, sir.
Based on where you have just landed, are you worried by the application coming up? Again, we have indication that there's going to be an application for review on the ruling given today. Is your side worried about the grateful, and I want to thank members of this committee. I see friends who have served you for a very long time in this committee, and I'm happy that once again I'm appearing before you. I am privileged.
The court has announced that it is settled law. Does not tell us to worry. All the cases they cited, the authorities that they put out there, they do not tell us to worry. But in all humility, we'll look at our books again to see perhaps if there's something that we missed. But we are still in the hands of the court. Colleagues, thank you. My colleague Nana B would translate.
Abusanfo yadamase. Ene eka ho a ene dai eyeda etoso edunan a yeshia na ene court etna ase no ade a no mo hwe mo bekaya na no ebra kwadubofo no ede to court anim se omabo mu nkura wie asem no oma from adansefo mawie enti omo de oma asem a omo de ba court no eho adanse nyina no omo de agu court anim awie ena eye a lawyer for so ejina honom emma eye respondent eye EC ene His Excellency the President nso de tu dwa se omo de omo di kan aka na bibia se asem we enya asem bia enu nti ebra kwadubofo no frɛ na dansefo na omu nyina ba be yi omo no opani ase edu nketia ba yehu nye kosi ye ensem ni sisi so eye Dr. Kwesa White nso bae yehu nye kosi ye ena opani rojo metonu nso ebae omu nyina bae no yen respondent ni agidi se omo asem no kra no asaba be hyen ye asem no mu kena se asem die di ho no mu ni nyina so bia enu nti kra no yen nakra emfrɛ ya dansefo eno na emise ema kwadubofo no etikopae na ene ade a na da court animu ane se eye no krasa ubetumi anase mmeramu ubetumi ahye obi a owo court a yedi nasem se onfa ho adansidie emmra na eno na court da court animu na court kansem a emu oduye pa yedi kan a omo kan omo se mmeramu untimi enhye obi bia se chinchina media homa so wo kon na bra ne begina adakam ne di adanse dabi etu behwe a court no agina eye emra any cases aba ensem a yedi no court angasa Nyamicha versus Ansa, Bawa versus Labi, Tai versus Siba, Ama versus Hydrophone. Ni nyina no court ejina so. E de kire say court ntimi nhye obi bia say ombema adansidie. Ebiem court nso gina Article 64 eno ne court a yegina nyina no ne farabai awo ye mra ba tan ne mu. Se omutumi a ekuta omo no ni nyina no gina Article 64 so. Enu ti no tumi bia enkuta omo na omo ntimi fa nya adwuma no. Enya ade a omo besoso so. Omo sa kan biem se eye no kra electoral chairperson mame tutinani a owo electoral commission na adwuma no emraba tan no na aso ne mu. Enu nti no ehu behia se abribia no one Ghana manfo nya bedi nkita ho. Nanso no se wo kan ne sa enu nkyere se ye wo mra foforo bi a also ye didi eye chairperson electoral commission asem ene mra foforo a menu mienu nso ye nya asem a ewo se eye court no edidi eno so court no editu dwa court ni sa kan asem bi se
make a policy decision. For example, when we asked the government took the decision to engage the members of the armed forces and the police on Operation Vanguard. This is what I'm saying, that you make a policy decision and you inform who the operators are, in this case the armed forces and the police, and they will take the action to do